docket today is the case of Williamson versus the Chaco Nation and the Chaco Indian Reservation. Both sides ready?
Yes, sir.
Okay, proceed.
May it please the court. My name is Erin Key, and I, along with my co-counsel, Joe Bermonti, represent the petitioner, Dr. Edward Williamson. At this time, we request to reserve 3 minutes of argument for rebuttal. My co-counsel will address why
Pull the microphone down a bit.
the jars that Dr. Williamson found on his own property, if the government were to take them, would be unconstitutional under the Fifth Amendment. During my time, I will explain why Harper Man is not Native American within the meaning of NECRA for 2 reasons. First, the statutory text clearly requires a connection with a presently existing tribe, people, or culture. And second, requiring this connection is consistent with the balance that NECRA strikes between science and culture. In turning to the facts, the record at page 2 shows they're not in dispute. During a 2008 storm, Dr. Williamson discovered 2 burial sites. The first contained Harper Man, human remains that are 14,000 years old.
But what if you say presently exists, but what if the tribe just stopped existing 100 years ago or 200 years ago? Is that completely outside the protection of the statute?
It's possible, Your Honor. This is remedial legislation, so the statute is very broad. It uses the term of or relating to. So that relating to term is useful because there are several different tribes that may be part. For example, the Iroquois Nation consists of the tribes the Mohawk and the Seneca tribe. So even if the Seneca tribe no longer existed, then it could still be relating to because that Iroquois Nation shares similarities. And the text of the statute reads that Native American means of or relating to a tribe, people, or culture that is indigenous.
So, counsel, when does the person become Native American?
Your Honor, for the purposes of NECRA, it's at the time of discovery. The dissent noted on page 21 that this is essential to the inquiry because we're not looking at Native American as applied to the person when they're alive. And this actually relates to my second point, which is the fact that in the lower court, respondents argued that results under NECRA would be absurd, that someone could be Native American one day and not the next. First, Native American, as used in NECRA, is not applied to people who are alive. When remains are discovered, that's when this definition applies.
So you're saying you cannot have any present living Native Americans in this country?
No, Your Honor. However, the definition refers to people which are indigenous. Now, that's a far broader scope. However, moving into the statute, once
Does that mean somebody who lives here?
I'm sorry, Your Honor?
Does that indigenous mean somebody who lives here, or born here, or family was here?
Indigenous is defined as living in a particular region in Merriam-Webster's dictionary. So this is consistent with requiring a present-day connection because of the tribe that is indigenous, so is living in the...
Indigenous to the United States.
Yes, Your Honor.
Counsel, if the individual is of a people, tribe, or culture, and you say they must be related to a particular present-day tribe, then why did Congress insert the words people or culture?
Your Honor, I think that analysis relates actually to cultural affiliation. What Your Honor referenced was a connection to a modern-day tribe as a defined term. Now, the statute NAGPRA defines American Indian as a federally recognized tribe, what we traditionally think of as Native American. But the statute goes beyond that with respect to Native American. It includes non-federally recognized tribes. So potentially, the parties may show that remains have a connection to a non-federally recognized Native American tribe. Then moving within the statute, the analysis would be whether they have a connection to an American Indian tribe, a federally recognized tribe.
Counsel, isn't this statute basically process-oriented? It establishes a process for the determination of, in this case, ownership?
Yes, Your Honor.
In fact, the section under which your case arises is called ownership, is it not?
Yes, Your Honor.
So is it not a two-step process, as the Ninth Circuit found. One step, you first determine if the individual is Native American, and then second, determine if the individual is or is not culturally affiliated to any federally recognized tribes?
Exactly, Your Honor. And respondents can't meet that first burden of showing that Harperman is Native American because that statute is in the present tense, which requires this connection.
If I might take you back, though, if you're saying that they can only be Native American if they're related to a present-day tribe, then we really only have one step instead of two steps.
Your Honor, the differentiation comes in that the fact that cultural affiliation used the defined term of American Indian, which is the federally recognized, which Your Honor references. But Native American is far more broad. It's of or relating to a tribe, people, or culture that's indigenous. So that encompasses non-federally recognized tribes. So
you're saying that you could be Native American, but the concept of Native American is mutable?
yes, Your Honor, to some extent that's true, and that's nothing new with jurisprudence in this country. Chapter 25 of the Code of Federal Regulations sets forth the process to become a recognized Native American tribe.
It became important when they could gamble.
I'm sorry?
It became important when they could run casinos.
Well, that's definitely part of it. And
All of a sudden, a whole group of people that never heard of Indians before became Indians overnight.
yes, Your Honor. And in a case
I
coming
almost did it myself.
that's fair. In a case coming out of the Ninth Circuit, it dealt with gaming regulations, with casino regulations. In the Guidaville Band of Pomo Indians versus the United States, the Sixth Circuit addressed a strikingly similar phrase at issue, which is land that is held in title by the United States. Now, the opposing party tried to say that is included was land that was previously held in title by the United States. And the Sixth Circuit said that that was not consistent with jurisprudence from the Supreme Court.
They didn't have to worry about the Indian Canada construction and the fact that we're dealing with a statute which by virtue of the area in which we're regulating needs to be construed broadly, correct?
To the contrary, Your Honor. In that case, they actually did speak of the Indian canon of construction, and they said that we have to resolve ambiguities in favor of Native Americans. But no ambiguity existed. And in South Carolina versus Catawba Tribe, the Supreme Court said that we can't use the Indian canon of construction to resolve an ambiguity that doesn't exist.
Why don't we look at the entire statute to try to draw the meaning from any given section?
Absolutely, Your Honor. And in this case,
Would it make any sense if we said, well, it just doesn't apply to anybody before X?
Your Honor, it's not whether it applies to a certain time frame. It's actually whether the tribe can show an existence today. And in fact, a case coming out...
Well, does it make any difference if it's in existence as opposed to where it's in existence?
No, Your Honor, as long as it's in existence in the United States.
So that if a tribe is in Florida, they could command the remains of somebody that they find in New Mexico?
Yes, Your Honor, and that's important because this is a broad statute, as Your Honor pointed out. The Chaco Nation doesn't have to show a connection of Harperman to the Chaco Nation. What they have to show is a connection with Harperman and any tribe, people, or culture that exists today. And that's what respondents can't do. They can't show this connection, which is entirely consistent, as Your Honor pointed out, with the statutory scheme.
Counsel, what is the purpose behind that?
Your Honor, the purpose is to return the bones of ancestors after graves have been desecrated of Native Americans.
And only those bones that have present-day politically recognized tribes, is that what you're saying?
Yes, Your Honor.
So your bones are not respected if you're not in a politically recognized tribe?
No, Your Honor, it is not about respect, and that can be seen in Dr. Williamson's actions. He did everything by the book. He contacted the medical examiner, the tribes, and he followed everything under the law. It's just that the law doesn't apply here. Now, this is consistent throughout the statute because the statute is trying to remedy wrongs. And if no one is around to have that wrong remedied, then in that case the statute simply doesn't apply.
Counsel, if we look at, would you say, Section 3 of the statute?
Yes, Your Honor.
In that statute, in Section 3, there's a priority of ownership, is there not?
Yes, Your Honor.
And that would be,
Kin, lineal descendant, cultural affiliation, or geographic.
would it also have federally recognized landowner? Lineal descendant, federally recognized landowner on federal land, on Indian land,
Yes, Your Honor.
culturally affiliated, and those with relationship.
Yes, Your Honor.
So in those categories, only one of the four categories that we just went through has a cultural affiliation to a present-day tribe. So is Congress telling us something when they did that, that cultural affiliation is not dispositive of subject matter jurisdiction?
No, Your Honor, because naturally kin would have that cultural affiliation. So that requirement would be met. And again, these are fallback provisions, which Your Honor refers to. These are if a cultural affiliation can't be determined.
So if a lineal descendant who would otherwise have disposition authority in this country is not a member of a tribe that has blood quantum, for instance, then they would be disenfranchised from directing the disposition of their ancestor, according to the definition that you propose.
Not at all, Your Honor, because again, this goes back to the fact that it has to be of or relating to a tribe, people, or culture. So that person would still be a people of that Native American tribe, and it doesn't have to be one that's federally recognized, and that person wouldn't have to be a registered member. But this geographic reference is a fallback, and so this is if no other lineal descendant or cultural affiliation can be found. And the section of the Code of Federal Regulations, 10.11, addresses in paragraph 3 these non-federally recognized tribes. It says that consultation should be done with these tribes.
Now, counsel, was consultation done in this instance?
Your Honor, in this instance, there was not a challenge. So the Chaco Nation came forward as the only claimant, so it didn't need to go to the committee for that type of consultation.
And this occurred on what land?
This was on Dr. Williamson's land.
And it's within the exterior boundaries of a tribe?
Yes, Your Honor.
Is that what gives us our NAGPRA jurisdiction?
Yes, Your Honor.
Is Dr. Williamson contesting the tribal land basis of his inholding?
Not at all, Your Honor. In this case, while the remains were found on tribal land, they still have to meet the threshold definition of Native American. The expert testimony in Bonnickson showed that there was a reason the court wanted this affiliation, because as Dr. Owsley put it, to simply group in the ancient remains with modern-day Native Americans would be a denial in and of itself of that person's history and culture. So by grouping Harper Man as a Native American with no further analysis, with no connection to a tribe that exists to speak for his rights today, and denying that study, it's denying him his own unique place in history.
Counsel, you referred to the case of Bonnickson versus the Corps of Engineers. Are you suggesting that we use that as presidential impact here, or form our decision?
Highly persuasive, Your Honor. Absolutely, it's not binding, but this court should adopt the reasoning because it was consistent with noticing that present-day connection, consistency throughout the entire statutory scheme.
In that case, in the Bonnickson case, there was prior to Ninth Circuit authority. I'm sorry.
Time has expired, but she may answer the question, so we will proceed with the question.
May I? Last question, ma'am? Thank you. In the Ninth Circuit, there was a prior case, I believe it was Coalition for Clean Air, that indicated that is means past, present, and future. The Bonnickson court decided not to acknowledge that precedent in making its decision. Do we then give weight to a court that does not give weight in its decision to other precedents?
Your Honor, that would absolutely be the correct path because this court disapproved of Coalition for Clean Air in Carr versus the United States. The majority dropped a footnote that said that the Ninth Circuit had not, in that instance, provided any support for using the present to include the past.
I note that this is not the first time the definition of the word is has been important.
Far more scandalous here, Your Honor.
Thank you very much. See.
May it please the court. My name is Joe Bramante. I also represent the petitioner, Dr. Edward Williamson. I'll explain that forcing Dr. Williamson to give these jars he found on his fee simple land to the Chaco Nation would be an unconstitutional taking in violation of the Fifth Amendment for two reasons. First, Dr. Williamson owns these jars. And second, the government's taking them without compensation. Congress enacted this
Well,
statute.
no one owns them if we say he owns them.
Yes, Your Honor.
And these are hardly abandoned jars that he just happened to find. These were very deliberately placed jars. What gives him his property right that there's a taking of? On what basis do you think he starts with the right to these?
The common law, Your Honor. While NAGPRA does apply in this case, and
Well, definitely would be in the common law, but under what theory?
under the theory of embedded property, Your Honor, on page 4 of the record it states that Dr. Williamson discovered these jars embedded in the soil on fee simple land. And so at the common law, the owner of the locus in quo, the landowner where the objects were found, has a right of possession and ownership interest in property found on the land.
Is there not a distinction, counsel, between abandoned property embedded in the soil and intentional placement such as burials?
Yes, Your Honor, there is, but it's important to note in this case that it is not clear that these jars were intentionally placed with these burial remains. Page 4 of the record states, clearly identifies the jars as fancy type 3C1B ware of the earlier Green Horizon culture. But the only thing it says about the human remains is that they're Native American. So unless respondents can tie these remains to the jars definitively, then Dr. Williamson's property interest in these jars he found on his land allows the takings clause to offer him some protection.
Perhaps colleagues here can correct me, but I thought in this case there was a stipulated fact that these were associated funerary objects.
Your Honor,
That it was associated with those human remains.
Dr. Williamson does concede that they are funerary objects, but not necessarily that they were associated with the human remains found at Site 2. It's,
But if by definition they were associated with some human remains, even if not those particular human remains, correct?
yes, Your Honor.
Okay, so they were placed there, correct?
Yes, yes,
They
Your
were
Honor.
not abandoned like some, or lost. They were very deliberately placed. And don't you think that impacts what kind of right he has in these properties?
Not necessarily, Your Honor. This argument that any objects near burial are a unified res with the human remains does not stand. It comes from maritime law in sunken ships, and that the objects found in a sunken ship are legally inseparable, but it has no applicability here.
Counsel, what meaning do we give to the fact that Congress determined this act to be the Native American graves protection? Is there not a unified res in the fact that funerary objects with human remains has a burial protection in full rather than a disaggregated interest?
No, Your Honor, there isn't a full protection extended to these jars. Dr. Williamson recognizes that there is a respect for human remains. He does not claim ownership of property interest in human remains in Site 2, and that's why he agreed to transfer those remains to the Chaco Nation.
But he does assert a property right to the human remains in Site 1.
Not a property interest, Your Honor, only that because the Harper man is not Native American, that NAGPRA cannot apply and force the disposition of the remains.
And
In other
who
words, the
decides?
Chaco owned it, they have to try to find some other way to own it.
Excuse me, Your Honor?
If Chaco claims ownership, they have to find some other way other than the particular law on which they're relying.
Yes, Your Honor. And looking at the common law, Dr. Williamson does have a property interest. When looking at newly discovered or rediscovered objects, there's three ways to assert property interest. The true owner, who has precedence above all others, then there's the finder or the landowner. The true owner in this case is the earlier Green Horizon culture, not the Chaco Nation. And they're gone. They have no one left to preserve their culture but Dr. Williamson. And as the landowner where these objects were found, he has a property interest in these jars. Respondents cite Sherrier versus Bell for the proposition that human remains are inseparable from any objects. But a closer look at Sherrier reveals that it actually supports Dr. Williamson's argument. In Sherrier, a self-titled, self-described amateur archaeologist went onto another's land, and there was some confusion about who owned the land. But he excavated over 2.5 tons of Native American graves and burial objects. The Louisiana Court of Appeals, in that case, stated that this man was essentially a grave robber, had no property interest in those remains. It sided with the landowner, the state of Louisiana, who had purchased that land. This court should do the same and side with the landowner in this case, Dr. Williamson.
Counsel, your Fifth Amendment claim relies upon the bundle of rights that a landowner has in their property, in their land.
Yes, ma'am.
So does that bundle of rights give them ownership of burials on it, human burials?
Not of the human burials, Your Honor, but of tangible items of property, a jar, a prototypical piece of property, it does give an ownership interest.
Would it make any difference if there was no question but that the jars were in fact with the body in a burial mode, in a shroud, or in some other way that they could say this definitely is connected to this individual?
Well, that would be a closer case, Your Honor. It still would not make a difference because the unified...
You wouldn't permit somebody to go into just rob graves of pots and artifacts, as long as they didn't disturb the human remains. Would you not argue that?
No, Your Honor, of course not.
Where do you draw the line?
We draw the line, it's a combination of facts in this case that make it unique. The fact that this is on private land, that the government can't show this definitive relationship.
And if they could
If
show
they
it,
could, of course.
if they could show it, would you still argue that because it was not the human remains, it could be taken by the owner of the land?
Yes, Your Honor, we still argue that because the human remains and the burial objects, Dr. Williamson, as fee simple, has an ownership interest in the objects, and the Chaco Nation, completely unrelated, can't uproot that property interest in the bundle of rights he has in his fee simple.
Well, so then you would agree that people could go on private land and actually rob graves, provided they didn't disturb the human remains?
No, Your Honor, but this case isn't a grave robbing. The record states
Well, I understand that, but I'm asking you if your position is such that if the owner of the land found a grave, it would be okay to go into the grave, take out objects other than the body.
Yes, Your Honor, if that unique circumstance arose in the future, then NAGPRA might not apply, but every jurisdiction in this country, every state has its own grave robbing statute that would cover that and punish that in accordance with the state law.
So there has to be a statute.
Yes, Your Honor, there does have to be a state statute who's better suited to enacting criminal law, as this court has suggested.
In this case, the federal statute that we're dealing with indicates that the land within the exterior boundaries of an Indian reservation is tribal land.
Yes, Your Honor.
So then, who makes the decision as to whether or not these objects are associated funerary objects or unassociated funerary objects?
The difference between associated funerary objects and unassociated funerary objects is only in who currently has possession of the jars. It's not, as it would seem, whether they are truly related or unrelated. It's that associated means in possession or control of a museum. Unassociated means not in possession or control of a museum.
So if associated funerary objects are associated with an individual, as opposed to disassociated with an individual, would that make a difference in the application of the law?
Absolutely, Your Honor.
So in this case, where you're indicating that these were, say, disassociated, correct?
Yes.
Who makes that threshold determination of association or disassociation on Indian land?
That should be something that would be handled at the district court. And because this was a motion for summary judgment, Dr. Williamson never had the opportunity to develop the record to show that this was dissociated, as Your Honor put it.
Well, is it your position that if we're not even talking about associated funerary objects, because they were not in the possession of the museum or a federal agency?
That's correct, Your Honor. They are funerary objects, just unassociated, within the definition of NAGPRA.
All right, does that make any difference?
No, Your Honor.
I'm troubled, counsel. This whole idea of associated and unassociated funerary objects relating to a museum, doesn't that pertain to sections 5, 6, and 7 of the law and have no applicability in section 3 of the law?
Respectfully, Your Honor, this case isn't even about the unassociated versus associated. It's just whether these jars are property. If they are property, then regardless of whether they're associated or unassociated, or regardless of what NAGPRA calls them, then Dr. Williamson is protected by the Constitution.
So if they are funerary, if they have relationship, they are burial objects, then you would concede that Dr. Williamson does not have a property interest. But if they are randomly deposited within the landscape that eroded, then they would be his property.
No, Your Honor. Either way, Dr. Williamson would have an ownership interest at the common law, because the common law doesn't distinguish, or excuse me, does distinguish between physical human remains and objects found. It can't be said that anything buried with a human is also treated with the same sanctity of human remains. For instance, if King Tut were buried in Nepal and his pyramid were opened with all the treasures of Egypt, all the treasures found in it, then under respondents' view of NAGPRA, the respondents' view of this case, then all of that, all of those treasures that inform history, inform our culture, would have to be deposited in the earth and lost.
Does NAGPRA in any way modify property rights as they're understood in common law? Is there any modification of those rights?
No, Your Honor. NAGPRA does not speak in terms of property rights, only in terms of control of the disposition of human remains and buried objects. The Secretary of the Interior is the one that brought up the possibility of takings clause violations. In 43 CFR 10.11, the section titled Disposition of Culturally Unidentifiable Human Remains, it says that while these culturally unidentifiable human remains must be repatriated to the tribe on whose tribal land they were found, any funerary objects found may be
But
repatriated.
that's kind of wishy-washy, right? I mean, the Secretary didn't really say it's going to be a taking. He just said it might be a taking. I'm a little concerned here. He certainly didn't opine that it was absolutely, did he? He or she, I don't remember.
That's correct, Your Honor. But what is absolutely certain is that the regulation, which is most on point in this case, states that repatriating funerary objects with culturally unidentifiable remains is only voluntary, not mandatory.
Counsel, doesn't that section 10.11 apply to collections in museums as opposed to new finds on the land where it's federal or Indian land, which is where you have perfect provenance? So for instance, you may have a museum, I don't know, down the street from us, the Field Museum, could have objects to which they claim a right. And NAGPRA would not require that something be given over for a culturally unidentifiable object. But where you have land, federal land, and this is Indian land, is it not, under federal jurisdiction?
Yes, Your Honor.
And so that would be very different than, say, a private museum, not?
It would be different, but the regulation would be no less on point in this case. The record states on page 4, the only finding regarding the human remains is that they're Native American. There's been no other finding with the specificity of the Harper Man or of these jars. So because the human remains are culturally unidentifiable, Dr. Williamson does not have to repatriate these jars.
Counsel, what is the common law, if we're talking about the common law, what is the common law burials in this country? What do we acknowledge in terms of the common law burials?
The common law burials, Your Honor, I see my time's up, may I briefly conclude? The common law burials is that human remains are treated with sanctity, so that there's no property interest in those remains. That's long-standing and established, but the same cannot be said for objects found in graves or near just a human body. And because these objects aren't treated with the same respect, that are not mandated by our jurisprudence to be treated with the same respect, Dr. Williamson has a property interest, and the government is unconstitutionally taking his property.
Thank you very much. Respondent?
Good afternoon, Your Honors, and may it please the Court. My name is Kelly Gabian, and I, along with my co-counsel, Stephanie Goldfarb, am here on behalf of Respondent, the Chaco Nation of the Chaco Indian Reservation of Depalia, asking that this Court affirm the decision of the 12th Circuit. I will be addressing the question of statutory interpretation, and my co-counsel will be addressing the takings clause question. Petitioner contends that a scientific interest should control today's decision. However, in the words of the late Senator Inouye, NAGPRA is first and foremost human rights legislation. It seeks to remedy past injustices and ensure justice in the future.
Well, you're asking us to rewrite NAGPRA?
No, Your Honor, simply to remember the words of one of the main drafters of NAGPRA in enacting NAGPRA.
And the fact that his words may not tie with the actual words of the statute, we ignore the words of the statute?
No, Your Honor, however, in this instance, they're congruent with the words of the statute and largely in support of it.
On history and true, what did you say your name was?
Kelly Fabian.
Thank you very much.
You're welcome, Your Honor.
What about the words "that is"? Those are two important words.
Those are two important words. Respondent would also point to the word indigenous and claim that that's an incredibly important word in this instance. As was discussed earlier, indigenous refers to born or produced naturally in a land or region. And in this instance, indigenous and indigeneity is something that is simply not subject to temporal change. Therefore, the word is, we should read the phrase within its entire context, looking also at indigeneity as controlling here.
So counsel, is this statute to be given broad impact to all those who are indigenous, such as any of us may be indigenous to our state, even though we have no, what would be otherwise Native American connection?
No, Your Honor, this is simply for the definition of Native American, of relating to a tribe, people, or culture that is indigenous, not to us as people, but those tribes, peoples, or cultures.
Well, do we ignore the indigenous to the United States language?
Your Honor, no, but we may read that as indigenous, to the present day geographical United States, as the court
So
did.
the fact that somebody could show specifically that the harbor man was French, it wouldn't make any difference.
No, Your Honor, because that would not be the United States.
Well, he's in the United States now. France used to own the area where he was found.
True.
And so that doesn't make any difference in your opinion.
No, Your Honor, present day geographical United States would encompass former French territory that is now the United States. I apologize. Additionally, this definition of Native American that we've been discussing today, there are many ambiguities present in this definition, as has been evidenced by several of the questions before the court.
Counsel, do you want us to find that the statute is ambiguous?
Yes, Your Honor.
Does that not have implications for other sections of the statute, for instance, the criminal section? Do you want us to invalidate that?
I apologize if I misspoke, Your Honor. Respondent contends that the definition of Native American is ambiguous, not the entire statute.
Does not Section 4, the criminal section, indicate that sales or trafficking in Native American human remains and cultural items are a violation of Title 18? And therefore, if the term Native American is ambiguous, do we not invalidate that section?
Your Honor, it would not be necessarily invalidated. It would just need to be broadly construed, given the Indian kind of construction, which states that any statute passed for the benefit of Indian tribes, if it's ambiguous, should be liberally construed in favor of Indian tribes. In the hypothetical that Your Honor put forth, it's possible that we could extend the definition of Native American goods potentially more broadly were a question to arise on what constituted a Native American good.
Well, under that approach, any statute is ambiguous.
Under the approach
Under your approach, you take a word that is clear as a bell to some people and say, oh no, it could mean something else, and therefore the entire statute and every statute has a built-in ambiguity back.
Your Honor, that is one interpretation. However, 2 points to that.
And it's presidential authority too.
Pardon?
It has presidential authority too.
That's just about the word is.
Oh, well. That's what I said when you did, I guess.
We're showing our age.
Well, many statutes do have ambiguity. That is certain, Your Honor. However, the statute has particular ambiguity. In addition to that, the Indian canon of construction does not apply to every statute. It's only statutes that are passed to the benefit of Indian tribes. And this, sorry.
Well, how does this benefit an Indian tribe?
NAGPRA's entire purpose is to benefit Indian tribes. It seeks to
As opposed to remains?
remains and Indian tribes, Your Honor. Remains that are connected to Indian tribes in some way. It's remedial legislation that seeks to make up for decades, centuries of injustices committed against Native Americans, Therefore, it should be interpreted broadly in favor of the Native Americans.
But you're asking us to apply it so broadly that it would protect remains that have absolutely no connection to current Native Americans. Adam and Eve, prehistoric remains, correct? No connection whatsoever.
Respectfully, Your Honor, these remains, first and foremost, do have to be human remains. Therefore, it would be difficult to go back into prehistoric remains. It may be some missing link in the evolutionary cycle. Therefore, it may not. There is a line, Your Honor. And
Are you saying that there's a time limit in NAGPRA, it only goes back so far?
there's no specific time limit delineated, and that's essentially, this court does in some way possibly need to draw that line.
So you would agree with opposing counsel that if there is no connectivity to a present-day political unit tribe, that the individual is not Native American?
No, Your Honor. What petitioner put forth essentially folds the two inquiries of NAGPRA. NAGPRA mandates a two-part analysis. It first asks whether the remains are Native American, and then it asks what tribe they're related to. And it need not be a presently existing tribe. It may be a tribe that has been indigenous to the United States. That need not be a presently
The
existing
Illinois
tribe.
tribe, for instance, Illinois Indian tribe was wiped out.
Correct, Your Honor. And there could be a tribe.
It's only in the state.
Pardon?
It's only in the name of the state.
Well, earlier hypothetical was put forth by Justice Smith about a tribe that was 100 years ago may have gone extinct and could not be afforded the protections of NAGPRA. If we were to interpret this narrowly and to hold it only to presently existing tribes, peoples, or cultures. Similarly, a tribe that went extinct in the 1970s before NAGPRA was implemented, that could be a tribe that may not be on the federal registry, and that could be a tribe that would not be afforded these protections. And that is simply against the purpose of NAGPRA. NAGPRA is seeking NAGPRA was passed for the benefit of Native Americans holistically, and it must be interpreted as such.
Councilman, in so doing, do we not run the risk in interpretations of NAGPRA of violating the 14th Amendment? Yes, does the statute go so far as to violate the 14th Amendment?
Respondent does not believe so, Your Honor. What specifically?
Equal protection?
Correct. No, Your Honor. Respondent does not believe that there is any equal protection issue, and one has not been put forth in today's case.
No special treatment for tribes not otherwise available to the rest of the culture?
Well, under this court's jurisprudence in the history of our nation, we do have a special treatment of Native Americans, as evidenced by the Indian Canyon of Construction. They are afforded special treatment as a special class. Therefore, it is congruent with this court and our nation to continue that broad.
Doesn't that canon of construction simply indicate that when there seems to be an ambiguity, the tie goes to the long-distance runner, to quote Justice Whitaker. So, but that doesn't mean that, even in that case, that the long-distance runner is given rights above those of the rest of the citizenry. So why would NAGPRA do that?
Why would NAGPRA give those
Does
up?
not NAGPRA violate the 14th Amendment if it gave them special rights?
Because those are also Native Americans. Again, it's about the special treatment of Native Americans in the history of this country, and it's in accordance with that.
I want to go back to your suggestion about tribes that disappeared in 1970. What are you saying?
Simply that, as in the hypothetical Your Honor put forth earlier about a tribe that potentially went extinct 100 years ago, a tribe such as that would not be able to, under the circumscribed definition of Native American that petitioner puts forth, would not be afforded the protection.
You're saying that would be protected.
I'm saying, no, would not under a narrow definition.
Under their definition, but under your definition and under the 12th Circuit's definition.
Correct.
that would certainly be
Correct,
protected.
Your Honor.
No, okay, you confused me. What about the fact that Congress didn't respond to the 9th Circuit, I think it was, admonition, it didn't amend the statute, and it had a clear opportunity to. So if it thought it was too narrow, it could have told us right then.
Correct, Your Honor. However, we should not give weight to the inaction of Congress over the action of Congress. And as the statute currently stands, as I stated, it is clearly ambiguous. And even within the definition, it could still be read, given the presence of indigenous, to mean tribes that are not presently existing. Further, the use of the word is here should not be controlling.
I'm sorry, you used the word what?
Is, I apologize. Verb tense need not be controlling here. I've spoken a lot about the word indigenous and respondent believes.
What about the dictionary? Doesn't it say that is means now and the future, but doesn't say anything about the past, right?
Correct, Your Honor. It doesn't say anything about the past, but it does not specifically exclude the past. It simply says the present and the future. I believe it was Justice Hutt that spoke to Coalition for Clean Air versus Southern California Edison, which stated that the present tense can refer to the past, present, and the future all at the same time. Now, while that is a Ninth Circuit case and should not necessarily be controlling here, it is instructive. Also, the fact that the Washington Court ignored it as suspect. Further, that is in line with current Senate legislative drafting manuals, which state that drafters should always use the present tense, unless there's a specific reason excluding it. So this is in accordance with both Senate legislative drafting, the decision in Coalition for Clean Air, and given its connection with the word indigenous, highlights the fact that this was not meant to be limited to presently existing.
Is there anything that we can look into the statute to help guide us in this determination?
I would point to the culturally unidentifiable remains section of NAGPRA. Were the statute to be construed narrowly, limited to only presently existing tribes, peoples, or cultures, it would render this entire portion of NAGPRA null. This is section 3006, which specifically anticipates a situation where cultural affiliation cannot be delineated. The remains are not affiliated to any existing tribe, people, or culture. Were we to limit the definition of Native American to presently existing tribes, peoples, or cultures, this section would be entirely null, which is completely incongruent with canons of statutory construction. Therefore, earlier, the petitioner put forth South Carolina v. Catawba as evidence of a case where the Indian canon of construction was not applied. As stated, there was no ambiguity found there. However, in this instance, as we've discussed, there's clearly ambiguity. It's inherent in our discussion of this term. The fact that there are so many questions surrounding this definition of Native American simply serves to highlight the ambiguity. The fact that there's a circuit split between the 9th Circuit and the 12th Circuit further highlights this ambiguity and further promotes that the Indian canon of construction must be applied. NAGPRA was clearly passed for the benefit of Indian tribes, and therefore the Indian canon of construction tells us that this term should be liberally construed, giving us a broad definition of the term Native American that is not limited to presently existing tribes, peoples, or cultures. Further, as Justice Frankfurter stated, even more than other domains of law, the intricacies and peculiarities of Indian law demand an appreciation of history. NAGPRA's remedial legislation is seeking to make up for centuries of injustices. Repatriating human remains to Native Americans is one means of making up for those injustices. It is why NAGPRA was passed, and it should help guide this court's decision today. With this, respondent respectfully asks that this court affirm the decision of the 12th Circuit. Thank you, Your Honors.
Concerned with substantive, constitutionally protected private property interests. Your Honors, no taking occurred here because these funerary objects are not now and never have been the private property of petitioner for purposes of the Fifth Amendment.
What's your best authority for that argument?
Well, Your Honor, it comes also from the common law, as did petitioner's authority. Under the common law, there is a long-standing tradition of treating human remains as not subject to private property claims. Similarly, many common law jurisdictions...
Now, you're speaking of the funerary objects, or you're speaking of the body of the Harbor Maid?
The Chaco Nation is speaking of the funerary objects. But many common law jurisdictions have extended that rule, the quasi-property interest governing human remains, and the...
What is your best case for that?
Well, Your Honor, there are several we can point to, but I think the most directly on point is a case from Missouri, Guthrie versus Weaver. In that case, the Missouri court held there can be no property in a corpse, and there is none in the shroud which surrounds it. In that case, the court very clearly states that there can be no private property interest.
In a corpse.
And or in the shroud.
That surrounds it.
That's correct, Your Honor.
What do you do when you find it 10 yards away, or 5 yards away from the...
Then it's not a shroud.
Make it a cigar lighter.
But Your Honors have all pointed to the fact that this is a case about line drawing. But many courts under the common law jurisprudence jurisprudence have extended the quasi-property interest over the human remains to objects other than shrouds, which are separate from the body.
What's your best case?
For example, Your Honor, in Grill versus Abel Funeral Home, an Ohio court held that a husband had an interest in the jewelry that was buried with his wife, a necklace or a ring that's placed in the casket.
Especially if it's on a finger.
Especially then, Your Honor. But also in Wright versus Harnett, a Texas court held that a wife has a right to determine objects placed in the casket that her husband is buried in. These cases suggest that under the common law jurisprudence in this country, there is this trend towards extending the quasi-property interest in the human remains to cover those objects that are buried along with the human remains.
You can't blame Texas common law on the rest of the country.
No, Your Honor. That's just one example. There are also many state statutes that support such a reading, specifically state statutes that provide that the human remains and the objects buried with human remains should be treated as a legally unified race.
But this statute doesn't say that, counsel, correct?
It does not state that they should be treated as a legally unified race.
It could have. Congress could have said that.
They could have, Your Honor, although the language respondent would suggest indicates a treatment in accordance with the legally unified race theory. Congress provides for the disposition of culturally unaffiliated associated funerary objects to go along with the disposition of the related human remains. And on the subject, as I just mentioned, associated funerary objects, respondent would like to just briefly, before we go any further, address the petitioner's claim that these objects are not associated funerary objects, because that would be very important to this court's determination if these objects didn't fall under NAGPRA. These objects are associated funerary objects, and for two important reasons. First, Justice Hutt, as you mentioned, the record below does indicate that these are associated funerary objects. The record, the recitation of the facts by the 12th Circuit on page 4 clearly says these are objects associated with the body. But even if that were not the case, petitioner's construction of the definition of associated funerary objects as provided in NAGPRA is simply incorrect. Petitioner said that in order to be an associated funerary object, the object would have to be in the possession of a museum. But if we in fact look to the statute itself, section 3001(3)(a) defines associated funerary objects. And it certainly does say that...
What does "and" mean?
And, as Your Honor is pointing to, means...
Does that make it ambiguous also?
It does not make it ambiguous, Your Honor, but it does indicate that in addition to associated funerary objects which are in the possession of museums, the "and" indicates that there is another group of objects which are defined as associated funerary objects. The statute goes on to say, which petitioner neglected, that other items exclusively made for burial purposes or to contain human remains shall be considered as associated funerary objects.
Counsel, Section 3 of NAGPRA applies to federal land and Indian land, correct?
That's correct.
We have a situation here, a case of first impression, where this is actually private land as an inholding within the exterior boundaries of a tribe. But what impact is that? Does that not give us cause to determine that this is tribal property, where there is in fact a private landowner from whose land these homes in?
It should not give this court cause, Your Honor, because the definition of tribal lands in NAGPRA specifically states that it encompasses all lands within the exterior boundaries of Native American reservations. So although certainly petitioner owns the land in fee simple, it's within the exterior boundaries of the Chico Indian Reservation.
But what is the bundle of rights under the Fifth Amendment that a property owner has in their land? How does this impact that bundle of rights?
Petitioner would argue that that bundle of rights is not impacted here because funerary objects cannot be private property. While petitioner may under the common law have a common law interest of other objects found buried in the soil, respondent would contend that based on the common law jurisprudence and the statutes suggested, that many jurisdictions in this country have said that funerary objects just simply aren't the sort of thing that you can have a private property interest, and for good policy reasons. Some of Your Honor's questions, Justice Kelly, you asked about line drawing. You asked about this idea that should concern us. Do we really want to say that if you do have a private property interest in burial objects, should you be able to strip a corpse of its shroud? What if the corpse is wearing a wedding ring, as Your Honor suggested? Should we say that it's okay for someone to rip the ring off of a corpse's finger simply because it's an object? No, we wouldn't say that, because those acts desecrate the body in the same way that claiming private property rights over the body would do.
Well, what do you do if a person had some extra funerary objects and took them out and just put them in the landfill, dumped them in the landfill, not associated with body, and it's on my property? Do I not get title to those funerary objects that are not being buried in connection with a burial?
Well, Your Honor, that depends. Is your private land within the boundaries of an Indian tribe? Then yes, those objects would be covered because, as I just mentioned, under the definition of associated funerary objects in NAGPRA, even though those objects are no longer with the body, because they are objects made for burial, they would still be associated funerary objects, even though they're no longer accompanying the body. When they were placed in the ground, they were placed with a specific spiritual, religious, cultural intent to accompany the body into the afterlife. And that's one of the reasons that NAGPRA doesn't just protect Native American human remains, it also protects funerary objects and objects of cultural and sacred significance.
If NAGPRA is ambiguous, as you have been arguing generally in support of the decision below, shouldn't we defer to the regulation, which makes a very clear distinction between human remains and funerary objects?
Well, respectfully, Your Honor, the regulation does not as clearly delineate that as your question would suggest, and this court should not be guided by that regulation for two reasons. First, in addition to the fact that the regulation does not specifically say they should be treated differently, that regulation should not be accorded any deference because this is a constitutional question. Although in this court's decision in Chevron, the court held that agency interpretations must be sustained, the court said in the same decision that that does not apply to constitutional questions, that in constitutional questions, this court need not rely on the agency interpretation, but should instead decide the question anew. And secondly, in promulgating that regulation, 43 CFR section 1011C, the Secretary of the Interior made very clear that the very reason he was doing it was because there were such large takings questions. It was in fact waiting for this court to rule on this question, waiting for a federal court to rule on this question rather than deciding the constitutional question itself. And finally, in addition to those reasons, as Justice Hutt mentioned, that regulation only pertains to objects in collections and private museums. It doesn't pertain to situations here.
But does not leave open the question, counsel, that now that it is put to this court, that this court could indicate that where private land is otherwise within the exterior boundaries, that provision of NAGPRA is constitutional, correct?
The court could certainly hold that, Your Honor, but it's respondent's contention that the court should not, because the Fifth Amendment only protects substantive private property interests, and it would go against the common law in this country and against the public policy concerns that NAGPRA was passed to further for this court to hold the other way. In addition to the line drawing problems that I've suggested, think about the incentives that holding in petitioner's favor would create. Were this court to hold that a taking exists when funerary objects are discovered on private property by the landowner, it provides an incentive for landowners and tribal lands, which there are a lot of them because under the General Allotment Act, this checkerboard system was created where there are many private landholders within the boundaries of Native American reservations. It would create an incentive for all of those private landowners to dig up the objects in their backyard because they can claim it as private property and then further claim just compensation or simply just keep those objects. That's exactly the kind of grave robbing and desecration that NAGPRA was enacted to prevent. One of the motivating policy concerns was a long history of desecration of Native American burial grounds, burial sites, grave robbing, individuals simply digging into the soil and taking what they wanted. This is exactly what motivated NAGPRA's passage, and if this court were to hold in petitioner's favor here, that would simply motivate that kind of behavior going forward in the future. In addition to the state laws that I've mentioned, there's also authority in federal statutes which suggest that human remains and associated funerary objects be treated as a legally unified race. In the decision below, the 12th Circuit pointed this out, relying on ARPA, the Archaeological Resources Protection Act. Now, it's not the act before the court, but it's instructive because ARPA defines a grave as any portion or piece of a grave. It includes everything within the grave. That suggests that...
What about stuff outside the grave?
It doesn't include things outside of the grave, Your Honor.
How about how far away from the grave does it have to be? Or how close does it have to be to become covered?
Well, Your Honor, under ARPA, it has to be in one burial site, but that definition is not controlling here because, as I've mentioned, the definition of associated funerary objects under NAGPRA only requires that they be objects that were originally for burial and to accompany the body into
Well,
burial.
are reasonably believed to have been placed with individual human remains.
Yes.
All right, now at some point, it's going to become not placed with human remains. What is that point, in your opinion?
Well, Your Honor, that point would be when there's no evidence to suggest that they were reasonably placed in burial with human remains.
Is there a boundary line, so many feet, so many meters, so many inches, so many yards?
No, Your Honor, NAGPRA doesn't suggest that it should be a distance question. It should be whether there's evidence suggesting that it was placed in burial. For example,
See, you
here.
indicated to a question I asked you earlier, that if a person just buried a bunch of funerary objects because he didn't want to use them anymore, or didn't want to use them, just going out of the business, that it was still covered.
Perhaps I misunderstood Your Honor's hypothetical before. I thought that Your Honor was positing a scenario where those objects were actually placed in burial with the body and then later thrown away. If that were the case, I could reply. But if I understand Your Honor's hypothetical now, if they were simply, objects that were sold that you could place in burial with a body and then toss away and never place with a body, then those objects certainly would not be covered. But in this case, there is strong evidence indicating that these objects were placed in burial intentionally with an individual. That evidence comes from the kill holes. This is a special type of pottery. The kill holes indicate that this was a special type of pottery used by the early Riverine Horizon culture in their burial rites. And we know this from anthropological research and from the anthropologist's notes in the record below. So in this case, there's no question whatsoever that these objects were originally placed with the body in a burial rite. Respondent believes that the record indicates they were placed with the body at Site 2. But so, Your Honor,
It already doesn't reflect that, does it?
well, Your Honor, I think as Justice Hutt indicated in her question, and as Respondent contends on page 4 of the 12th Circuit's recitation of the facts says that these objects were associated with the human remains at Site 2. So it's Respondent's contention that that was established in the record before the 12th Circuit.
Counsel, there is a distinction in law at times between human remains in a burial, which are res religiosa, and other grave goods, which may be the subject of larceny and grave robbing. There is no property right in human remains, but there is in the object. So does this difference of treatment within the larger rubric of property law mitigate against your unified race theory?
That difference of treatment does mitigate against my theory, but as Respondent has advanced, there's also a counterweight in the common law, a tradition of many common law jurisdictions that don't apply that distinction in law.
Well, then what is the impact of state law, and is there law in Napoleon, if I may?
I never fight with another judge.
If you're finished with your question. There is no law on this question in Napoleon. So state law may be influential in other states and other jurisdictions that might have informed this inquiry, but because there is no law on the record here in Napoleon, we can only be guided by the Native American Graves Protection and Repatriation Act, which protects not just human remains. Thank you.
Two brief points on rebuttal, Your Honors. The first is with respect to the first issue. And as Your Honor pointed out, policy doesn't trump plain language. In the insurance law, there's a canon of construction that we construe against the drafter in favor of the insured. But what we do first is make sure we're dealing with an insurance contract. Here, we're dealing with a canon of construction to construe in favor of Native Americans when respondents haven't established the Harper man is Native American. With respect to the second point, Your Honors, this can be a win-win situation. The Chaco Nation is very concerned about reburying these jars, and that's what NAGPRA does. It gives them not a property interest, but a control over the disposition. Now, if Dr. Williamson is compensated for the taking of this private property, the Chaco Nation will have control of the jars, and they will be free to rebury them.
Who decides whether or not these are funerary objects?
Your Honor, the respondents would have the initial burden to prove that. Again, this was a motion for summary judgment, so petitioners contend that burden was not met.
I find it illegal to sell
Yes, Your Honor, in the sense that if they are private property, then he should be compensated. There are separate state laws with respect to transfer of Native American objects, but those laws aren't at issue here. For these reasons, we ask this court to reverse the decision of the 12th Circuit in all respects.
Are we done?
All right. Sorry.
We have conferred, we have arrived at a decision after wrestling and hurling ourselves around the room. A couple of fistfights broke up. And it will be announced tonight. Unfortunately, I will not be there tonight, so this is my last chance to talk to you. I have been on this court of appeals here since January 3rd, 1975. I was on 2 other courts and sat on appellate courts, trial courts for 10 years, and I was a trial lawyer. I have rarely heard any group of lawyers match the 4 I heard today. It was spectacularly done, all 4. I commend you. If all of the lawyers who appeared before the court on which I sit and the courts on which I sat were as good as you 4, my life would have been a breeze, and I would still have a full head of hair. But I congratulate you all. It's a wonderful job. You're going to make magnificent, you are magnificent lawyers. All you need is a passport to stamp on it. That's a cinch. Anyway, thank you very much for the pleasant experience of listening to you. I congratulate you all.
Thank you.
I would only really echo that. It was really, I mean, honestly, and not to take anything away from past years when I've done this contest, but this was really fabulous, all the way around, really, really strong. And I guess one thing I want to sort of comment that all of you did well was concede when you had to concede and move on, which is, you know, you gained so much credibility doing that, and you, all 4 of you, at least at one point, did that, and it was lovely.
I agree. I've only been on the Court of Appeals for 21 years. So I was a child. But you can go into practice today and come out to the 10th Circuit and argue and be as good as anybody we have out there. I would make one comment that make sure you understand the question. And if you don't hesitate to say, did you mean X? Or did you mean Y? It just makes it a little easier when you discover that you misunderstood the question. But that doesn't take away from the great job that both groups did, and it was a pleasure to be here.
I have to say, this is my 4th year being here for the competition, but my 1st year sitting in the bench on the finals, and I'm honored to be with these colleagues. And I have to say, I echo their feelings in terms of the strength of the advocacy that's been done. So I've been operating for 10 years, and but I have to say that my memory is not that bad. But the strength of advocacy, the attention to purpose, the focus, the unflappable. We were pretty hard on all of you, and you didn't flail under pressure, and you weren't shaking visibly, at least not from what we could see. And so you have great careers in front of you as advocates, and it's a great credit to you and your schools. And I have to say that I give great credit to you, Judge, and to this court, and to the DePaul for Law School for inviting us to DePaulia, and to hosting this competition to turn out 100 great cultural property lawyers every year, because you're a credit to the area, and I hope that you will be applying for my job in the near future. If you look at my picture in the program, that was before the culturally unidentifiable rule that you all talked about here today. I thought you were going to talk about my counsel, and I didn't know how I would refer to that if you started talking about counsel who gave us that opinion. But it has been a great honor to be involved with NAGPRA as well. A little different than being on the bench. So give give bureaucracy a thought. It's not what the pundits on TV say, it's actually pretty fun. So, but I thank you all. It takes a great deal of effort to be in the court. The people who wrote this opinion wrote a brilliant opinion and great bench materials. So it's all of the time and effort that you all put in. It's a credit to all of you, and we are in your